Well, hello everyone and welcome to Uncivil Law. For today's story, we are reacting to the U.S. Supreme Court, which tomorrow will be having oral arguments relating to ghost guns. These are guns that people manufacture themselves and so do not have a serial number on them. And, the U.S. government apparently is really, really worried about them and concerned about them and would like to regulate them. So this case is all about whether or not they can do that. And the Supreme Court's going to hold oral argument on that. Can they regulate ghost guns, which is to say guns that people manufacture themselves from various kits? All right, so to determine that, we're going to read the briefs in this case. We, of course, will start with the brief for the government, and then we will respond with the brief for Miss VanDerStok, Jennifer VanDerStok, who is bringing this case. So Merrick versus Jen. All right, let's see what we got in this case. The question presented, a very long question presented, by the way. In the Gun Control Act of 1968, Congress imposed a licensing, background check, record keeping, and serialization, meaning literally put the serial number on the gun, requirement on persons engaged in the business of importing, manufacturing, or dealing firearms. The word business being pretty key there, by the way. The act defined a firearm to include any weapon which will or is designed to or may readily be converted to expel a projectile by the action of an explosive, as well as the frame or receiver of such a weapon. In 2022, the Bureau of Alcohol, Tobacco, Firearms, and Explosives issued a regulation clarifying that certain products that can be readily converted into an operational firearm or functional frame or receiver fall within the definition. In other words, gun kits. In other words, 80% lowers. Okay. The Fifth Circuit held that those regulations are inconsistent with the act, because of course it did. The Fifth Circuit does that kind of thing. The questions thus presented are whether a weapons part kit that's designed to or may readily be completed, assembled, restored, or otherwise converted to expel a projectile by action of an explosive is a firearm, and whether a partially complete, disassembled, or non-functional frame or receiver, think 80% lower here, by the way, that's designed to or may readily be completed, assembled, restored, or otherwise converted to function as a frame is a frame regulated by the act. Okay, great. All right, let's skip that and go down to the substantive argument. Opinion below, don't care. All right. This statement concerns a 2020, this case concerns a 2022 rule issued by the ATF to address an urgent public safety and law enforcement crisis posed by exponential rise of untraceable firearms, commonly called ghost guns. Ghost guns could be made from kits and parts that were widely available online and allowed anyone with basic tools and rudimentary skills to assemble a fully functional firearm in as little as 20 minutes. Because some manufacturers of those kits and parts asserted they were not firearms regulated by federal law and thus sold them without serial numbers, transfer records, or background checks, ghost guns were attractive to criminals, minors, and others who were legally prohibited from buying firearms. Responding to the concern and consistent with ATF's long-standing interpretation and implementation of the Gun Control Act of 1968, the rule makes clear that weapon part kits and partially completed frames and receivers that can readily be converted into functional firearms or complete frames and receivers qualify as a regulated firearm. The rule does not prohibit the purchase, sale, or possession of any firearm, nor does it prohibit any individual lawfully entitled to possess firearm from making one at home. Instead, it simply ensures that ghost guns are subject to the same straightforward and inexpensive administrative requirements that apply to commercial sales of all other firearms. But the Fifth Circuit invalidated the relevant provisions of the rule, adopting an interpretation of the act that permits ready evasion of its central requirements in contravention of text, context, and common sense. Okay, well, the Department of Justice certainly has its view of the thing. Congress adopted the Gun Control Act in response to widespread traffic of firearms. Congress found that the ease to which any person, including criminals and juveniles, can acquire firearms is a significant factor in the prevalence of lawfulness and violent crime. Congress was particularly concerned with mail order distribution of firearms, which allowed buyers to evade state and local requirements. back in a time when you could buy firearms by the Sears catalog. In the act, Congress imposed requirements on persons engaged in the business of importing, manufacture, or dealer firearms. I would say the business of being, the kind of the key element there for my money. The business of. Such a person must obtain a firearms license, keep records of acquisition and transfer of firearms, and conduct a background check. In other words, become an FFL. Importers and manufacturers are also required to mark firearms with a serial number. The twin goals of the Act's comprehensive scheme are to keep guns out of the hands of criminals and others who should not have them, and to assist law enforcement authorities in investigation of serious crimes. The background check requirement serves Congress's principal purpose in enacting the statute, to curb crime by keeping firearms out of the hands of those not legally entitled to possess them, including felons. And the record-keeping and serialization requirements allow law enforcement to determine where, by whom, or when a firearm was manufactured and to whom it was sold or otherwise transferred. These requirements help fight serious crime. When police officers retrieve a gun at the crime scene, they can trace it back to the buyer and consider him to be a suspect. Over 8,500 law enforcement agencies use ATF's system for tracing firearms recovered at the scene. Congress broadly defined firearms as any weapon, including a starter gun, which will, or is designed to, or may readily be converted to, expel a projectile by the action of an explosive, the frame or receiver of such a weapon, any firearm muffler or firearm silencer, or any destructive device. By including frame or receiver of such the weapon, Congress ensured that the key structural component of the firearm is subject to the serial number, background check, and record-keeping requirements, even if sold alone. Congress did not, however, define the terms frame or receiver. So it's like, okay, well, you need a frame. That's where all the gun parts go. But what is a frame? That's a good question. Congress authorized the Attorney General to prescribe such rules and regulations as are necessary to carry out the act. The Attorney General has delegated the authority to ATF. In addition to ensuring regulations and other general guidance, ATF ensures manufacturers to submit potentially regulated items on a voluntary basis so the agency can assess whether they qualify as firearms under the act. Either that or they're just trying to get themselves a hold of all the cool guns. It's like, yes, I'm going to examine the gun and make sure that it's legal. That's what I'm going to do. Not take it out to the range and play with it. Yeah. I mean, being an ATF examiner sounds like a half-decent job. Maybe I should be an ATF examiner. Then I get all the cool guns. They'll just send them to me in the mail. ATF responds to such submissions with classification letters, setting forth agency's official procedures concerning the status of firearms under federal law. In 1968, shortly after Congress adopted the act, ATF's predecessor agency promulgated a regulation defining frame or receiver as that part of the firearm which provides housing for the hammer, bolt, or breech block and firing mechanism, and which is usually threaded at its forward position to receive a barrel. Although the 1968 regulations do not expressly address the issue, the ATF has long held that a frame or receiver need not be complete or functional in order to qualify as a frame or receiver under the Act. Instead, the agency recognized that a piece of metal, plastic, or other material becomes a frame or receiver when it's received a critical stage of manufacture. That is, when the product is brought to a stage of completeness that will allow it to accept the firearm components for which it's designed, using basic tools in a reasonable amount of time, which sounds pretty floaty to me. That approach is reflected in dozens of classification letters issued over the past half century. For example, ATF has consistently found that a partially complete frame qualifies as a firearms if it can readily be converted to functional condition, or if they're basically complete and require only a small amount of machining to attain functionality. What is a small amount, by the way? And no one knows the answer to this question. No one knows the question, right? So we've been talking about 80% receivers, or 80, that's a legal threshold, but no one knows. They're just guessing. And it's whatever it takes, a small amount of machining, whatever that means. What exactly at what point is it at what point does it count? I mean, a 0% complete is just a block of steel or a block of aluminum, right? It's just a lump of metal. So 0% is a lump of metal, and 100% is, the thing that, actually you buy in the store. So exactly how far along do you need to be is something that you're guessing. Yeah, that's why they're called 80%. There was a time when ATF said 20% was enough, and then they changed their mind. Exactly. But no one knows for sure because the law doesn't define it. Yeah. ATF has long considered the length of time necessary to complete the frame or receiver as making a classification determination. In 1980, for example, the ATF explained an unfinished receiver that would likely qualify as a firearm. That's definitely what you want to hear from your ATF. If it could be converted to functional condition within a few hours using common hand tools. And ATF has classified such items as firearms. For example, a receiver that required approximately 75 minutes of work to become functional. Relying on those considerations, ATF has also concluded that certain items are not sufficiently complete to be regulated as firearm or receiver for the moment. For example, ATF has determined that products are not frames or receivers where major machining operations were required to permit an item to be used as a frame, or where the completion of missing steps cannot be accomplished without common hand tools. Well, I mean, everything can be accomplished with common hand tools if you believe enough, right? Give me a lump of metal and a file, and I'll give you a receiver if you give me enough time, I'm gonna go whittle that down, man. In recent years, technological advances have made it easier for companies to manufacture and sell firearm part kits and easy to complete frames or receivers that allow anyone with basic tools to assemble a functional firearm quickly and easily, often in the matter of minutes. For example, the Buy, Build, Shoot kit, marketed by Respondent Polymer 80. I wonder how they got their name. I wonder why they're called Polymer 80. Allowed a purchaser to assemble a fully functioning Glock variant semi-automatic pistol in as little as 21 minutes. Not 20, mind you. It can't be done in 20. It cannot be done in 20. You must have at least 21. That extra minute's really critical. Similarly, companies have marketed partially complete or unassembled frames or receivers that can be readily completed or assembled to functioning state, for example, by removing a few temporary plastic rails, a process that takes minutes. Some manufacturers of those kits and parts asserted they were not firearms regulated by the Act and sold them without complying with the Act's requirements. Those firearms, commonly called ghost guns, because of their lack of serial numbers, were widely available online. And the lack of serial numbers, transfer records, and background checks made ghost guns uniquely attractive to people who were legally prohibited from buying guns or planned to use them in a crime. As a result, police departments around the nation confronted an explosion of crime involving ghost guns. In 2017, law enforcement agencies submitted roughly 1,600 ghost guns to tracing. That's going to be hard. By 2021, that number was more than 19,000, an increase of more than 1,000% in just 4 years. And those submissions to ATF have almost been entirely futile because the lack of serial numbers and transfer records makes ghost guns nearly impossible to trace. Out of 45,240 unserialized firearms submitted for tracing between 2016 and 2021, ATF was able to complete only 445 traces to an individual purchase, a success rate of less than 1%. Yeah. In 2021, ATF issued a notice, a proposed rulemaking to clarify the definition of firearm and provide for a more comprehensive definition of frame or receiver. After public comment, ATF promulgated a rule issue which took effect. The rule makes a variety of updates to ATF regulations, including definitional provisions and record keeping, serialization, and other requirements. This case concerns two discrete provisions of the rule that clarify the Act's applications of ghost guns. First, the rule reinforces the Act's definition of firearm, which encompasses any weapon that's designed to or may readily be converted to in a functional firearm. It includes certain weapon part kits. Tracing the statutory language, the rule defines firearm. They're really trying to pin this on the statutory language, obviously, because Chevron is dead. So they're going to like, no, this is exactly what the statutory language requires. This is all the statute language, Your Honor. Well, at least they're making arguments that, you know, are not like bullshit. So at least they're trying to root themselves in statute, and I appreciate that. Only 133 watching. Can you guys hit the like button, please, and maybe tell a friend and encourage people? I kind of thought this thing would be popular. Kind of thought people would like to hear about this, but, you know, only 133 watching. Could we hit the like button and maybe, you know, could we take a shot at Chevron? Chevron is dead. Chevron is dead. Chevron is dead. We use poisonous gases and we poisoned its asses. Chevron is dead. Dun, 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 dun. All right. The ATF explained that kits covered in the rule fit within the natural ring of statutory language, and the rule simply makes explicit that manufacturers and sellers of kits are subject to the same regulatory requirements as applicable to manufacturers, which doesn't make quite sense to me. I'm on the same time as watching the Watchers member stream. Oh. The rule requires readily as a process, action, or physical state that's fairly or reasonably efficient. Tell watching the Watchers. Tell Robert we're covering Second Amendment stuff. He'll like that kind of thing. Yeah. And provisions with respect to classifications of firearm factors released relevant in making this determination to include time, ease, expertise, equipment, parts available, expense, scope, and feasibility. ATF explained that it is defined readily by start of a common dictionary definition of that term, and then provide more clarity by listing relevant factors the courts have adopted. Second, the rule clarifies the undefined term frame and receiver in the Act's definition of firearm includes a partially complete, disassembled, or non-functional frame or receiver, including a frame or receiver part kits that's designed to or may readily be completed, assembled, or restored, or otherwise converted to a firearm or range or receiver. ATF has long interpreted the Act to cover partially complete or non-functional frames and receivers that can be made functional using basic tools in a reasonable amount of time. ATF acknowledged that in applying the standard, it has not previously considered other materials sold with a partially complete frame or receiver, such as templates and jigs, but the ATF concluded those items can serve the same purpose as indexing or partial machining on the frame or receiver itself, allowing a buyer to quickly and easily complete the frame. That's fun. So before, there was like marks made on the thing itself to show you like where to make the cuts. And they're like, oh, you know, that you can't do that. So they're like, no problem. We'll just submit this template or jig that's separate. It's like, well, you can't do that either. You can't include the jig either because it's functionally the same as marking the piece of steel itself. So, yeah. The rule thus specifies that in determining whether a part qualifies as a frame or receiver, ATF may consider any associated templates, jigs, molds, equipment, tools, instructions, guides, or marketing materials that are sold, distributed, or processed with the kit item or kit. At the request of commenter seeking additional clarity, the rule explicitly includes any forging, casting, or other unmachined body that has not yet reached a stage of manufacture where it's clearly identifiable as an unfinished component part of the weapon. Well, what does that mean? What does that mean? Does that mean 80%? Does it mean 70%? Does it mean 60%? What does it mean? What does it mean? ATF explained this exclusion makes clear the components that sell or distribute only finished frames or receiver of the sort purchased in bulk are not required to be licensed or marked as articles with serial numbers. The rule also lists examples of products that fall within its interpretation frame or receiver. A kit containing the parts necessary and comparable jig or template. So a person with online instructions and common hand tools may readily complete or assemble the parts to function as a frame or receiver is complete. So a partially completed billet or blank that is machined, molded, or manufactured with one or more template holes drilled or indexed in the correct location, so a person with common hand tools may readily complete it, is a frame or receiver. In contrast, a billet or blank that lacks indexing, machining, or forming of critical interior areas and sold without instructions is not a receiver. So I suppose you have to sell the instructions separately. You can't sell them together as part of a kit. You can't sell them together. You have to sell them separately. And it's like, yeah, and also the fact that the instructions are the problem, as Tony points out, is also a bit of a First Amendment problem. I could make a lot of money selling kits with jigs index marks to make an F-16 style fighter from a kit. If you can make an F-16 from a kit, man, then I guess God bless you. I mean, that seems like that's going to be really problematic. Really big kit. Really big kit. If you can make an F-16 from a kit, I'd love to see you try. Oh my God. The rule interpretation of an act does not inhibit the manufacture of any firearm or sale of firearm to any individual lawfully entitled to possess one. Instead, the rule simply clarifies the act requires commercial manufacturers and sellers of covered weapon part kits and partially completed frames or receivers to obtain licenses, mark their products with serial numbers, conduct background checks, and keep records. Oh, just the bureaucracy. Just the bureaucracy, yeah. Anyone know where to get the jet fuel? I don't feel comfortable making it. No, you got to distill your own, man. You got to distill your own jet fuel. Get yourself some crude and get yourself, a nice little distillation facility in the back and do it Appalachian style, man. You can make your own jet fuel. In fact, the fact that you're doing it from crude is too much. You should be making it from corn. With that Mountain Dew added energy, man. These are the same conditions and qualifications on commercial sale firearms, which is kind of the problem. That around 80,000 licensed manufacturers and distributors of firearms comply with in the millions of transactions each year. The rule's interpretation of the acts also does not prohibit a person who's lawfully entitled to possess a firearm from making the firearm at home. To the contrary, the rules repeat emphasis that firearms privately made by non-prohibited persons solely for personal use generally do not come under the purview of the act. The rule's interpretation, therefore, does not restrict law-abiding citizens' ability to make their own firearms from parts, for the moment it doesn't, without a license so long as they're not engaged in the business of manufacturing firearms, and does not require such individuals to mark with the serial number of firearms they make for their personal use. Just the lower itself has to be marked. Respondents, 2 individuals, 2 advocacy organizations, and 5 entities that manufacture or distribute some products filed or intervened in the suit. 3 manufacturing respondents are already FFLs. As relevant here, respondents challenge the parts of the rule clarifying that certain weapon parts fall within the definition of firearm. The district court grants respondents' motion for summary judgment, concluding the 2 challenged provisions of the rule contradict the act. The court vacated the entire rule, including its many unchallenged provisions, without addressing ATF's express specification that the provisions of the rule are severable. The government appealed and sought stay. The Fifth Circuit stayed the ruling. Okay, skip that part. This is all just procedural stuff. Let's see, whatever. Okay, is there anything new in the argument we haven't talked about? Fifth Circuit argument would frustrate the act. If a state placed a tax on the sale of tables, chairs, couches, and bookshelves, IKEA could not avoid paying by insisting that it does not sell any of those items, and instead selling furniture part kits that must be assembled by the purchaser. Well, they very well may be able to, incidentally, depending on the state law. So, like, the premise doesn't quite hold. All right? If a state placed a tax on the sale of tables, chairs, couches, and bookshelves, would IKEA have to pay the tax based on the fact that you assemble them? I don't know. It depends on the definitions, I guess, under the operative state law. What did the legislature actually pass? I mean, if you build it yourself, from parts. A company in the business of selling kits that can be assembled into working firearms in minutes and are designed, marketed, and used for that purpose is in the business of selling firearms. And here Congress expressly defined a firearm to include not just one functional weapon, but one that may be converted to function. Furniture is a fundamental right, don't you know? Preach. All right, I think that's enough of that. Let's read the response. I think we got the gist from the government section. Let's read what Jennifer has to say. Jennifer, the hero of our story is named Jennifer. Excuse me. The Gun Control Act of 1968 is the principal federal law regulating the American conventional firearm market. A key provision of the law is definition of firearm. Items defined as firearms are subject to substantial federal statutory requirement, including serialization requirement for manufacturer and background check requirements for retailers and purchasers. Items not within the definition of firearm are not subject to requirement. As relevant here, the relevant law defines firearms as any weapon, including a starter gun, which will or is designed to or may readily be converted to expel a projectile by action of an explosive, the frame or receiver of any such weapon. The term frame or receiver was defined by regulation shortly after the enactment of the law. Consistent with ordinary meaning, the regulation defined frame or receiver as that part of the firearm which provides housing for the hammer, bolt, or breech block and firing mechanism, and which is usually threaded at its forward position to receive a barrel. This initial regulatory definition remained unchanged until 2022 and said nothing about precursors of frames or receivers or part kits. By 2022, Congress had considered several bills to amend the Gun Control Act to expressly cover precursors of frames and receivers and part kits, but none had been enacted. In April 2022, ATF took matters into its own hand by promulgating the challenged rule. The rule defined the definition of a firearm in two pertinent respects. First, the rule expanded the definition of frame or receiver to include precursors that may readily be converted to function as a frame or receiver. Second, the rule expanded the definition of firearm to include any weapon parts kits that may readily be converted to expel a projectile by action of the explosive. The rule also changed the regulatory definition of frame or receiver to require housing only of the breech block for receivers, or one component of the firing mechanism for frames. These changes are inconsistent with the Gun Control Act's definition of firearm. With respect to precursors of frames or receivers, it'd be strange to say that an item that must be converted, that is, say, transformed to functions of frame or receiver, is a frame or receiver. The interpretive difficulty, I love that phrase by the way, interpretive difficulty, the interpretive difficulty is enhanced by the immediate statutory context, namely the express inclusion of readily converted language in Part A of the definition of firearm coupled with its exclusion from Part B. It is also enhanced by the broader statutory context, most pertinent the gun control's treatment of frames or receivers of machine guns as machine guns. Under the rule, heretofore perfectly legal semi-automatic firearms receivers likely qualify as machine guns because they could be readily converted to machine gun receivers under ATF standards. ATF rule thus risks turning law-abiding firearms owners into felons. And even if the analysis were incorrect, ATF expressions would still be unlawful because ATF has changed the underlying definition of frame and receiver in ways that depart from the ordinary meaning of the firearms. Red or blue pill, baby? Red pill. Nah, you know what? Blue pill. I think I'm with Cypher on this one. Ignorance is bliss. Just give me steak. Just give me steak and a job as an actor. Yeah, I think blue pill, baby. Team, I'm on team #steak. How about I take both pills, Morpheus? How about that? See what you do then. ATF rule thus risks turning law-abiding firearms into felons. And even if the analysis were incorrect, ATF's expansion would still be unlawful because ATF has changed the underlying definition of frame and receiver in ways that depart from the ordinary meaning of those terms. With respect to the parts kits, the GCA covers only weapons that can be readily converted into firearms. An incomplete collection of parts is not a weapon. What is more, the Gun Control Act replaced the previous definition of firearm under federal law, which would include all firearm parts. Ooh. Now that's a pretty good argument. I like that one right there. The definition changed it to exclude the parts into something more specific, with a definition that was focused on the single part, the frame or receiver. Yet the only marginal difference the weapon part kit's provision makes is an attempt to bring within that definition of firearms collections of parts that lack a frame or receiver. How are those terms are defined? Such kits are not firearms under the GCA. I like that argument very much. That's a good argument. It's like it was in the definition and they removed it out. While the foregoing demonstrates the rule exceeds ATF authority, to the extent that any doubt remains, it should be resolved against the agency. That is required both by the canon of constitutional avoidance and the rule of lenity. There's ongoing policy debate about whether privately made firearms should be regulated by the federal government. ATF insists they should be, pointing to firearm tracing figures allegedly showing an increase in criminal misuse of firearms. There are reasons to question the ATF claims, but the claims are not at issue. Rather, the decisive fact in this case is Congress's decision, in the Gun Control Act, to focus on the commercial firearm market rather than the private market. Yeah, that's for me is pretty good stuff. I think so, yeah. Accordingly, the Gun Control Act does not reach the items used in private firearms that they attempt to regulate. To the extent of changed circumstances called for by a change of regulatory approach, that change must be made by Congress. I like that. That's very good. I like that. That's pretty good. Let's go through a brief history of firearms law. Congress enacted the National Firearms Act in 1934 as the first federal statute regulating firearms. The purpose of the National Firearms Act was to provide for taxation of manufacturers, importers, and dealers in certain firearms and machine guns. Yeah. To tax the sale or other disposal of firearms and to restrict importation regulation of transportation thereof. Hold on, I need to ask Joe something. I saw your petition on the emergency docket period. Are you still waiting to file the other one, question mark? If so, when were you looking to file, question mark? I could take another look at it today. I'm streaming right now and I'm looking for things to do, lol. Let's see what Joe says. The NFA defined firearm to include only certain short-barreled shotguns or rifles, machine guns, and firearm silencer or mufflers. Imposed a tax on making and transferring of firearms defined by the NFA, as well as special occupational tax on persons and entities engaged in the business of importing, manufacturing, and dealing in firearms. 4 years later, Congress augmented the NFA with the Federal Firearms Act, which was less restrictive but had a broader scope. The statute defined firearm to include any weapon designed to expel a projectile or projectiles by the action of explosive on any part or such weapon. For 30 years, Congress occasionally amended the NFA and FFA in response to changes in firearms. For instance, in the 60s, the NFA's restrictions on short-barreled shotguns were limited to weapons that were capable of using the energy of the explosive in a fixed shotgun shell to fire the projectile. After court decisions holding that short-barrel shotguns were missing a firing pin, were not covered by the NFA because they were incapable of firing, Congress amended several NFA definitions in 1968 to capture firearms that could readily be restored to functionality. So people were selling shotguns without a firing pin and saying that they didn't work. So, they don't work. They're shotguns, but they don't have a firing pin, so they won't fire. The year 1968 brought the most significant changes to federal regulations since 1934, as Congress replaced the FFA with the Gun Control Act, the first comprehensive federal arms statute. The Gun Control Act created a new 4-part definition of firearm, and has remained the same since. While the FFA has treated any part of firearm as a firearm, experience has proven that it's impractical to have controls over each small part of a firearm. Thus, the gun control superseding definition substitute only major parts of the firearm. Okay, I like that very much. That's a very good argument. I like that argument very much. I like this argument. This argument really speaks to me. So the FFA had treated any part as the firearm. The Gun Control Act changed it to be more narrow. So I like that argument very much because it's like Congress chose to replace broader language with narrower language. Right. So if Congress had just written the narrow language in the first place, you might have it's a different argument, right? If they had just written the narrow argument in narrow language in the first place, you're like, okay, what exactly does that mean? But here they're explicitly replacing something with something else. And of course, Congress, when they pass laws, means to change something. That's what they do. It's like there's a reason they changed it, right? So the change is material. So the change of the language is interpreted by the change, as well as its own text. That's the history component of interpretation. Well, one of the history components of interpretation. So, all that stuff. All right, let's see what Joe says. Yeah, Congress is a smart Congress. Yes, okay. All right. Joe says he wants to join me in 20 minutes. Okay. I'll set up a stream. All right, so Joe is going to join me in 20 minutes. Exciting. Joe Neerman. If it was Joe Rogan going to join me in 20 minutes, it'd be a much different reaction, I assure you. Who gives a fuck about an Oxford comma? Law. I love my Oxford comma button. All right. I think I'm going to end the stream and then go ahead and just get started on a new stream. I think it'll be good. So this will be our third stream for the day. Let's go ahead and schedule a new stream. Who gives a fucks about an Oxford comma? Do. You just got here. We got another stream, baby. I like this argument though about the change in the law. That one really speaks to me. So that's a pretty good argument. I think they have a pretty decent chance of winning. I think they have a pretty decent chance of winning. I don't think it's by any means assured, but I think they've got a pretty decent chance of winning. John Roberts is going to go all squish. So, yeah. I sure did. All right, let's schedule. Let's schedule a stream with Joe. Who gives a fuck about last week, comma? Why do I have the old man dancing from the Six Flag commercials in my head right now? That is why of all the things to go through my head did I choose the music from the ad with the dancing man for Six Flags? My brain has betrayed me. You're seeing Quiznos? We've got the subs! We got the subs for you! We got the subs! Holy shit, Quiznos. No, get out of my dreams. We love the moon. Am I weightlifting? I sure as hell am. In fact, I've got a personal trainer now. A virtual personal trainer, but I've got a personal trainer. I'm not sure about it, by the way. I'm still like not sure about it, but I'm giving it a shot today. We'll see how it turns out. I need the I can't decide whether you should live or die music. That's what I need. I need the I can't decide if you should live or die as a sound clip. Yeah. I can't decide whether you should live or die. You probably go to heaven. Please don't hang your head and cry. No wonder why. My heart is dead inside. It's cold and hard and petrified. Lock the doors and close the lines. We're going for a ride. Don't four-letter fucking kiss you both at the same time. Smells like something not forgotten. Curled and dyed up, now it's rotten. I've got to hand it to you. You play by all the same rules, and now you got me crazy. Makes me do well lazy. I can't decide whether you should live or die. Probably go to heaven. Please don't hang your head and cry. No wonder why. All right, I'm going to see you in about 3 minutes or so. I'm going to get some water, stretch my legs, and I'll see you in about 3 minutes, okay? Love you. Bye.